I would like to welcome today's presenter, Joanna Kim-Brunetti, EVP of Regulatory Affairs, Chief Legal Officer at Trusaic. Joanna, a former partner with Aiken Gump, has over 20 years of experience advising clients on a wide range of employment, tax, intellectual property, and other related business issues. She also holds a BSc degree in chemical engineering from the University of California, Berkeley, and a JD from Loyola Law School with honors. She's also was president of the Korean American Bar Association, Rising Star, Super Lawyers, co-chair of various subcommittees under the American Bar Association and the Los Angeles County Bar Association. So without further ado, welcome, Joanna.
Thank you, Mike, and thank you all for attending today's webinar. So this morning or this afternoon, depending on where you are, we will be talking about preparing for California's SB 1162 pay data reporting law. And as you may already know, this is really an amendment to 973. And 973 went into effect last year. 1162 adds to it, and we'll drill down on the details later in the slides. So basically 1162 overall will go into effect, for purposes of 2022 reporting, which goes next year. So what we're talking about is really amending SB 973 and adding to it. Among those requirements is the sort of separate pay data reporting requirements for labor contractors. These are workers via third-party staffing agencies, often thought of as temp workers, but basically they're hired by another company and kind of leased over to you. It also SB 1162 also adds in this sort of mean and median pay data reporting. Before, for 973, it's just basically putting in the data for pay, the sort of raw pay data. And we'll talk about sort of the issues with that raw pay data. But now, in addition to that, you're also calculating the mean and median. And finally, 1162, it basically adds to SB 73 from an enforcement standpoint. It adds in certain enforcement like civil penalties, and we'll get into that as well. It also, separately, in addition to the pay data reporting, it also adds in pay transparency requirements. I'm sure you've heard about that. That stuff goes into effect Jan 1, and that's going to be an important addition. So that's just kind of the overview of SB 1162. Now, let me take a step back. What is driving this? Why is this happening? And we can get into some of those details. But at the end of the day, there's really a cultural shift in public sentiment, which is increasingly demanding pay equity, and pay transparency is one of the sort of components of getting to pay equity. A few years ago, we started with movements like Me Too, Time's Up, Black Lives Matter, and of course, just sort of the reporting you heard with COVID. And you're like, well, gosh, what does COVID have anything to do with pay equity? Well, what they have found, all these studies had shown that there was inequitable impact on certain minority groups. And so this was just another kind of highlight of the sort of disparity that was going on. And then separately from the sort of pay inequity, sort of impact in the US, we also are dealing with a tight labor market. I'm sure you've all heard about the Great Resignation, all these people leaving, changing jobs, et cetera. And it's just resulting in significant competition for talent. And more recent news is talk about sort of a, kind of a tamping down of that tight labor market, but it's still tight. It's still hard to get good help. And where that competition is particularly acute is in the professional workforce. And so, and those are the ones that are doing all the hybrid and sort of where COVID had an impact on remote workers. And, and kind of so the remote workers are, sort of less likely to stick to a job just from the lack of sort of the social glue that in-person working has created. So there's all these sort of effects going on, but at the end of the day, it is making employers really encouraging them, whether via stick or carrot, encouraging them to push for pay equity. And so that's sort of the sort of landscape of why all of these laws have come into effect. Okay, let's go into the next slide. Okay, so hold on, my apologies. So what is pay data reporting? It is an important component of pay equity. As I said, pay equity has different components. There's pay data reporting, and I alluded to earlier, pay transparency. So pay data reporting, for specifically in California, and what underlies 1162 and its predecessor, SB 973, the pay data reporting is basically pay that you're submitting to a government agency. And what is intended by it is to encourage employers to look at their pay equity practices, or their pay practices to ensure pay equity. If you don't already realize this pay data reporting is just submitting whatever it is people are getting paid. It's not taking into account, why, for example, suppose you have Susie and John in the roughly same position, but John's getting paid more. It's just going to show that, let's say John's male, Susie's female. So, sort of on a larger scale, you've got, let's say hypothetically, you have men getting paid more than women in a particular job category. And so what the pay data reporting will show is that men are getting paid more than women. But what it doesn't account for are legitimate business factors that could justify why each particular employee is getting paid more than their counterparts. So for example, suppose John has a lot more experience than Susie. Suppose that John's been with the company longer than Susie. Other reasons why you would have two employees that are roughly in the same position, but one's getting paid more than another. The pay data reporting doesn't look at that. It just looks at how much are men getting paid, how much are women getting paid, how much are the different ethnicities and races, how much they're getting paid just as a group, without looking, sort of more granularly in terms of why there might be good reasons for that. So it's just looking at the raw pay data, which are typically larger than the actual pay differences from a pay discrimination standpoint, for example. And so if you actually want to know what the real risk is from a pay gap, you really need to run a statistical analysis on the pay data after accounting for these factors that I just mentioned. So you understand what the real, sort of the true pay differences are. Otherwise, you're just kind of showing this sort of the raw pay data without accounting for legitimate pay differences, which may, you may have no pay, actual pay inequity. But like, as I said, this sort of reporting is this, sort of a bigger raw picture. And, the agency is leaving it up to the employer to actually run the analysis to figure out if that's an issue. So what you're doing is you're submitting this report, and hopefully you're actually running the analysis to see what the report is really saying. Okay, next slide. Okay, so let's look at SB 1162 overall. What are the key components? I put the logo there for the Civil Rights Department. It used to be, until July of this year, it was run by the Department of Fair Employment and Housing, or DFEH. It was basically renamed as the California Civil Rights Department. So if you're wondering, well, oh gosh, we were supposed to submit the DFEH and now we're submitting it to the CRD, what's going on? It's a different name, but the change in name really ought to signal like sort of the importance of enforcement. And that's why they changed it. Okay. So what we're talking about is this change in name really kind of speaking to the intent of the agency's emphasis to prevent discrimination and enforce compliance. Okay, so let's look at SB 973 and how it's amended. It's, generally speaking, SB 973 applies to employers with at least 100 employees. With the amendment of 1162, as I mentioned earlier, you have to report the mean and median pay data for combinations of gender, race, ethnicity. You're also going to submit a separate pay data report for labor contractors, which we just talked about earlier, the same thing. So if you've got at least 100 labor contractors, you're going to be submitting a separate pay data report. One of the things that it did remove, but it really didn't take away the sort of burden that goes with this pay data reporting. It removed the option to submit this EEO1 report in lieu of the pay data report. So it actually, before you could under certain circumstances, submit that EEO1 report. Now it is a different report, and you can't just substitute it. It does remove the requirements for employers with multiple establishments to submit this consolidated report. And if you're not familiar with the EEOC or EEO1 reporting, you would be reporting a report for each establishment, basically each, just generally speaking, like each location, for example, if you have multiple locations. And you'd also submit a consolidated report for all of the locations. Now, you don't have to do the sort of multiple establishment requirement to submit this consolidated report. Now, separately, and not with respect to pay data reporting, but pay transparency, SB 1162 amends that the California pay transparency, where if you have at least 15 employees, you have to disclose pay scale. This is both for like job postings that you do yourself or through third parties, like if you're using, I don't know, Indeed or some other company to do the posting for you. You have to actually post the pay scale. And what do I mean by pay scale? I mean the minimum and the maximum of the pay range for that position that the employer reasonably believes, is applicable to the job. Now, what this change was, and this goes into effect January 1, is this, this sort of pay scale disclosure. The law before was if the job applicant requested it and had an initial interview, then you were required to provide the pay range. Now this is just for the public, and so that's a big deal. And it really is going to signal to you that you want to think about this now. And if you haven't done so already, get your figure out what your compensation structure is for all the positions, because you're going to want to, have that in mind instead of kind of ad hoc coming up with, oh, we've got this position that's come up and we are going to need to give a range. Like you don't want to do this ad hoc. You want to do it, in a disciplined manner for the entire organization and not just for, looking at the one job in particular, because you may find that that's going to run into other issues, and I'm going to get into that as well. So what you're looking at is, job ranges, pay scale for job applicants, but in addition, it requires all employers to disclose pay scale for a position in which the employee is currently employed. Now, it's only if they make the request, but so you're now basically posting publicly what the pay ranges are for new positions. Well, that means that your current employees are going to see those. And so they may ask, well, hey, what's the range for mine? So you want to plan for that. Don't wait until they actually ask you, because you're going to have that at the ready. Okay, let's go to the next slide. Okay, I want to take a moment for labor contractors. Like SB 973 did not include labor contractors. It was limited to employees. Now with 1162, it adds to that and it creates an additional reporting for labor contractors. And I want to talk about that a little bit, like, well, why are we bothering? They're not our employees. Well, the reason is, there's been this drive for labor contractors. It streamlines the hiring process. It's quicker. It's just basically a more agile way of bringing in folks to, basically supplement your workforce. And employers often think of it as a supplement as opposed to part of the workforce, plainly flexible. And, in theory, you can avoid the employer status. And that is in theory, because I'm not going to get into the reasons why, but just because you're saying someone is an independent contractor, there are always the potential for misclassification issues. Now, what the reality is that labor contractors are often paid less from a total compensation standpoint. You have to consider when you hire or retain an independent contractor through, say, a staffing agency, the agency is taking a cut. And so, you're like, well, no, actually, they're getting paid the same as our current employees, or, from how much the employer is laying out. But in reality, that individual independent contractor is taking home less. So, that is what studies have shown, that labor contractors are getting paid less than employees in general. And there's also just disparate treatment. They don't get the same kind of perks that employees get. And what studies have shown is there's overrepresentation of minorities and women in these contract roles, particularly in tech companies. And so what I'm getting at is there is, what the impact has been of, for labor contractors is that there is this sort of, disparity of as between men and women, and as between whites and and non-whites. So this kind of disparate treatment is also, the SB 1162 is trying to address that from a pay equity standpoint. And so as a result, 1162 has included a separate reporting requirement for labor contractors. Next slide. Okay, so one of the things that I want to mention about 1162 is its record keeping. And so from a practical standpoint, what do employers need to keep track of? So you're going to have to keep track of the job titles and the wage history for each position. And really, in reality, you're going to want to do it for each employee. You're going to want to maintain these records for the duration of employment and for at least 3 years after termination. So this kind of goes part and parcel with the bigger picture of you want to have an overall sort of analysis of what it is that you are paying for each position, not just the ones that you're immediately posting come Jan 1, but you're going to want to have analysis done of like, what are our pay ranges? Do not determine those on the fly. Figure those out in advance. Obviously, you're going to want to adjust that over time. One that will take into account what's going on in the market. Obviously, the formula that you use, method that you use to come up with it, you want some flexibility, but you want to have a plan instead of coming up with it on an ad hoc basis. These records are required to be open to the California Labor Commissioner so they can check it out. And if you fail to do this, basically in a litigation context, it's going to create a rebuttable presumption in favor of an employee's claim. So if an employee, claims that there was, pay discrimination, and you do not keep the records, the fact that you didn't is going to create a presumption that those records are not going to, be helpful to you, if you will. Okay, next slide. So, okay, so we talked about the pay data that's going to be submitted. What's it going to be used for, right? And this is kind of what I alluded to about those raw pay gaps and why it doesn't show the underlying pay disparity. So you're going to want to know what those raw pay gaps, what it actually means. So what the California Civil Rights Department is, can use these reports for is one, identify pay discrimination. And as I said, all they're getting is the raw pay data. It's not going to look at the justifications, if you will, for why there's pay gaps, say, between men and women. They also want to look at the pay data to identify wage patterns. So they're doing it kind of more broadly to see sort of we as a state, what's going on in terms of pay. So, in terms of wage patterns, whether it's by gender or race, ethnicity. And depending on sort of what the reports show, it will help them prioritize their resources in terms of who they're going to go after. And obviously, it's supposedly more effective for prosecuting employers with pay inequity practices. So, this kind of data is being submitted to the CRD, and these are the kind of things, they will be potentially looking at with that data, your data. So keep that in mind. Okay, next slide. So what are the deadlines? We obviously have that January 1 deadline coming up. Those are those pay scale disclosures that I was talking about for job listings, as well as getting ready in case an employee makes a request. And also, Jan 1 is the time where you're going to want to make sure you have those pay records established for your current employees. Now, the deadline for the pay data reporting has been shifted. In what we're seeing now is we've got for next year, the deadline is May 10, and then I think the deadline used to be like March. Now the deadline is now shifted annually to May. So as I said, you've got that mean and median pay data reporting that you're going to have to submit for the 2022 year by May 10, 2023. Next slide. What happens if you don't bother? Okay, so when SB 973 came out before, the enforcement mechanism was essentially if you failed to submit the reporting, the agency could go ahead and basically sue you to file. And perhaps they realized that that wasn't enough teeth. And what they are basically, they turned it into more of a civil penalty. So you're looking at now, it's $100 per employee for failing to file this mandated pay data report. And if it's a repeated violation, it's $200 per employee. So you're like, well, what's the big deal? $100, $200. Well, it's per employee. So we give you this example here really to kind of emphasize that this could be a lot. So let's say your organization has 5,000 employees. Well, for the first time, that's a $500,000 penalty. And the second time, it's $1 million penalty. So this could be really huge. This is not a report you want to fail to submit. We noticed this year, with respect to last year, the agency had issued letters saying, "Hey, you failed to submit this." So they're paying attention. But you do not want to miss the pay data reporting if it applies to you, i.e., at least 100 employees or 100 labor contractors or both. And so separately, 1162 also provides a penalty enforcement mechanism with regard to the pay scale disclosures, the pay transparency. Employers that fail to post pay scale in a job listing can be fined up to $10,000 for each violation. So these are real penalties that you're going to want to pay attention to and make sure that you are not subject to. Next slide. Now, we gave some fictitious examples, with regard to 1162 to help kind of illustrate sort of who it applies to. And these came from real world questions. So here's a question was, we have 5 sales employees in California reporting to our establishment in Washington. And their question was, we only need to report for the 5 California employees, correct? Now, we didn't drill down to some of the nuances of the underlying 973, because that's its own webinar, quite frankly. But one of the things that's a little bit nuanced about the California pay data reporting is it says it applies to employers and with 100 employees. Those 100 employees do not have to all be in California. Generally speaking, you have to, if in the employee context, right, separate additional requirement with regard to labor contractors. But if you are looking at employees, as long as you have 100 employees in the US, that's enough to trigger it. And what that means is if you have at least one employee assigned in California, that's enough to trigger the underlying SB 973 now 1162, this pay data reporting. Now, you don't have to report for the employees outside of California, but you do have to report for those who are either working in California or assigned to California establishment. Now, if you have no California establishment, then you're only required to report the employees working in California. Again, for any employer with at least 100 employees in the US. Okay, next slide. Next slide. Okay, so here's another example, again, from a real world question. Our staffing agency has 550 contractors and 100 full-time employees. Can you tell us what we have to submit? Okay, so basically you're going to be submitting 2 different reports, one for the labor contractors and one for the employees. Now, in this example, it talks about 100 full-time employees. Now, it's any employees. So if you have 100 employees, that's all that is required to trigger the pay data reporting. So what you're going to be doing is each report is going to be requiring reporting within each job category, the mean and median hourly rate for each combination of gender, race, ethnicity. Next slide. Another real world example. And these are all, these are all, fictitious companies, but came from real world questions from real companies. It's not these companies specifically, because these are ones that we created. Okay, our California tech firm has 70 full-time employees and 30 contract workers. How do we make sure we comply? Must comply with the pay scale disclosures for job listings. There's no need to report on the mean and median data because you haven't hit the 100 employees or 100 labor contractor threshold. But I want to point out there is a risk of employee misclassification. So, for example, if those 30 contractors are determined to be employees, you would have, the pay data reporting would have been triggered. And so, and this is kind of one of the things that pay data reporting, the agency is really, can get you at with is, and why they put in the sort of labor contractors. They like some employers really trying to avoid the expense, if you will, with employees, is they've been using these labor contractors, but really in reality, they're very much their employees. They're doing the same things that their employees do. And so the idea is if you are misclassified, if an employee is misclassified, because really they're exactly the same thing as your employees, you just paying them differently, you are going to run into this risk of it being determined that these independent contractors are in reality employees. Now, in this case, let's say you had 70 employees and 30 contract workers. Now, they're going to say, well, no, you actually had 100 employees, and you had those. You hit the 100 employee threshold. So now you should be, you were subject to it, and you didn't report. You failed to report. Now maybe the penalties will get triggered against you. So that's the issue. Next slide. Okay, I put this slide in here because, I talked early on about this kind of cultural shift, really kind of pressing for pay equity, and, being mindful for your company. You're going to want to know what's coming up. Don't just wait for it to hit you. California is a very, I'll just say, proactive state. It's often kind of the model for things. In terms of laws and legislations benefiting employees. And while ideally it's a win-win situation, a lot of times these employee benefit laws are often viewed by employers as an additional burden. And it may be from a cost standpoint, but as we move towards pay equity, there's going to be more laws like that. And I'll get into it, like Illinois SB 1480. In some ways, it's actually stricter than California, because now not only is it requiring a similar pay data reporting like California, but it's also requiring a certification that you've actually complied with pay equity laws. I don't know how you're going to know that that is true to sign a certificate to that effect unless you've actually done the audit to make sure that that is the case. So that's Illinois. In Illinois, that law, I believe, that goes into effect next year or the year after. It's very soon. It's coming up. So we talked about how 1162 adds in these pay scale disclosure requirements starting Jan 1. It is not novel. There was one that was actually in Colorado. The Colorado one went into effect on Jan 1, 2021. And now we kind of had a little bit of a tsunami of states that have followed suit really very recently. You've got, in addition to Colorado, which perhaps was the starter, you had Connecticut, Maryland, Nevada, Rhode Island, Washington. Oh, I put Colorado twice, and certain cities that were doing it individually. And those included New York City. That went into effect November 1 of this year. And then Toledo, Cincinnati, Ohio. There's other cities. These are just kind of an example. there are some states that's pending right now. New York is pending as a state, Massachusetts. And like, it's not a coincidence that all of these things are going on really within the last year. Inc. magazine called 2022 the year of pay transparency. It's really, these are often sort of Democrat-run states, but they are all really looking at this issue about pay transparency, and that is in fact the trend. It may be that all the states are gearing towards that. We've got salary history bans in 21 states and DC, and there, and a number of city specific bans, but that is the trend. And from my perspective, it seems like we really ought to have more of a federal structure rather than this kind of patchwork among the states. But it's very unclear as to whether or not feds are going to do that. Okay, next slide. I want to mention this interim amendment 1162 because I think that it signals that this might be coming in the future. In this sort of interim version that ultimately got, was on the cutting board or cutting floor, was to actually require the agency, whether it was the DFEH, now the CRD, to publish the employer pay data. At the very last amendment, it was eliminated at the State Assembly Appropriations Committee. And there was, certainly arguments for it and against it, and ultimately it was eliminated out of the final version that became law. But what's interesting to note is this is not all that different from what you see in the UK, for example. The UK has a requirement where employers, not the agency, employers have to publish their pay gaps in their own website. It's kind of a shaming law, and it came out just a few years ago. And oftentimes, like, laws are not necessarily created in a vacuum. They look to see what others are doing and say, hey, is that something we want to do for our own jurisdiction? Is that helpful to our constituents? So looking internationally is of value to see, and looking at what other states are doing to see if, gosh, maybe this is coming down the pipe. So that's why I mentioned this, because it didn't make it this time, but it may come back. There was a assembly bill maybe 3 or 4 years ago that was in the works. It didn't make it at that time. It was very much modeled after the UK version. But these laws are looking at what other jurisdictions are doing, especially if they see a lot of success in it, in terms of the policies they want to advocate. And they come up over and over again. So we may see this in the future. Next slide. Now, as I had alluded to, really the idea that we really probably want some kind of federal, kind of framework instead of this patchwork. And the Biden administration introduced a sort of national strategy for achieving gender equality. And with respect to federal contractors, OFCCP's directive has made clear that contractors need to conduct pay equity audits. I want to take a moment to talk about this EEO1 component 2 data reporting. It came out a couple of years. Well, it was supposed to go into effect starting in 2017. There was a shift in, there was a change in the White House, and so that got halted. And after some litigation, the net result was that this essentially pay data reporting was applicable only for the 2017 and 2018 year. However, the EEOC commissioner has indicated that it's likely to return. Now, I want to mention that the California pay data reporting is, looks a lot like the EEO1. It's more complicated, but its framework started with the EEO1 component 2 data reporting when that got halted, as I just talked about. And then, not to miss a step, they added this reporting requirement once the federal law was no longer in effect, and they made it a little bit more complicated. Illinois did a similar thing because their pay data reporting is also based on that same EEO1 component 2 reporting. And now we're talking about it coming back. How is that going to impact the state reporting if and when the EEO1 component 2 reporting comes back? we shall see. It may very well be you end up having dual requirements. There are other laws where there was a state one, a federal one went into effect, but the federal one didn't basically eliminate the state ones. And so then you ended up having two sets of requirements. So that ends up making things more complicated. All right, next slide. So with all of that, if I hadn't, discussed before, you want to do a proactive pay equity audit. Now, unlike, say, for example, Iceland actually requires you by statute to do a pay equity audit. Here, by the way, I see there's a bunch of questions. One, we will get to all the questions, not necessarily during this presentation. I'm going to try to save a few minutes to take some Q&A, but we will, in one form or another, we will answer all of your questions. So, if there's any concern on that, I wanted to allay that. So with regard to conducting a proactive pay equity, you're going to want to establish the metrics and a measurement system for tracking progress towards pay equity. You're going to want to assess and analyze your compensation policies to ensure sort of globally pay equity, meaning globally your entire workforce, not on this ad hoc analysis. And, once you've done that, it gives you the opportunity to really kind of communicate to your workforce where you stand on pay equity. And if you take a position on that, showing your progress, hopefully you are actually making progress to your workforce, to your investors and other key stakeholders. Like, you can use this pay equity audit, not just to handle your reporting, but you can use this as a vehicle to, really advance your pay equity in the larger framework, your, diversity, equity, inclusion policies and commitments. So also this, the pay data reporting, one of the elements of like switching from just data, like submit your data, to now you're also required to run median and mean numbers, calculate that and submitting that. It really is just one more reason why you're going to want to do it, a statistical analysis to make sure you're doing it right. Okay, next slide. Now, Trusaic provides our platform, Pay Parity, and it really addresses all of this, and designed to address the issues that pay data reporting and all the sort of pay equity related laws are getting towards. You're going to analyze all forms of compensation. You can pinpoint pay disparities really at the intersection of gender and race, ethnicity. I mention that because, like, for example, the OFCCP had noted you want to do it at the intersection. What do I mean by that? You have, you can run the analysis for race, you can run the analysis for gender, but there is a compounding effect. So, for example, Latino women, they, in a particular company might have this compounding effect. So you want to look at that so you're not looking at each issue in a vacuum with respect to the other issues. Our software allows you to avoid wage compression. And what do I mean by that? Well, wage compression, that's when like newly hired, less experienced employees earn close to what current employees make. And that often happens because, let's say, Susie was hired 10 years ago and was offered a starting salary that was commensurate with that time in the market at that time. But over time, employees continue to earn what's called for, standard raises. Then they're just trucking along. 10 years later, they're getting their sort of standard raises. And then wage compression comes into play when you're, like, say, an incoming employee, John, gets a starting salary that's closer to Susie's because of basically the market outpacing the company's standard pay increases. And so, John's ultimately getting a higher salary relative to the experience of Susie. And so, you got the manager who's kind of trucking along slowly, and then you get a new one who's just right under there. And again, with this, when you consider that in the context of pay transparency and, these job postings coming out publicly, well, Susie, the manager, is going to see that her direct report is getting $1 less than she is. That's the kind of issue that wage compression, that's what wage compression is. So, you running this overall pay equity analysis, figuring out what the pay disparities are, looking at what the market provides and sort of taking into all of that. Very hard to do by the back of, the back of an envelope or even a spreadsheet. So this is something you really want to, do in a disciplined manner and a reliable manner. And what the platform allows is to, communicate whatever progress you are making and confidently because it's reliable. It allows you to maintain attorney-client privilege. And you can use it as a tool to comply with pay equity laws. And this monitoring will allow you sort of where you are. A lot of times, if you want to achieve pay equity for your organization, you need to know where you are. And then you need to measure, are you getting there? Like how, you got to know where you are. Then you want to set your goals from that. And then you want to track what, are you getting closer? Are you getting, going backwards? So you want to look at that. Next slide. One of the benefits of the pay parity platform is this equal pay estimator. And what that allows you to do is post salary ranges with it. So what the platform does is it actually utilizes Lightcast as a third-party labor market data. It's just this robust, voluminous data of what the industry is paying geographically and by industry. So you're using that data and you're incorporating it into your analysis to figure out what your pay ranges are. So here, for example, this is a software engineer manager in San Francisco. And you may have this internal pre-approved range. That's the bottom bar. And then you have your external estimated range. That's what the market data has. And then you look at the current employees. Those are the little dots. Those are the dots of like, what are your employees actually getting paid for that position? And then the top one gives you a range of where your pay equity, like if you offer a range from, 118.8 thousand, 100,000, sorry, and 126,000, if you give it in that range, you will not muck up your pay equity analysis. Now, that doesn't mean you necessarily want to pick a range in that range. But what that tells you is to give you guidance. So let's say you're like, well, the market is particularly heated. This is a particularly unique situation. So we actually going to want to, do 135 or whatever, 135,000 or whatever the number is. And so you can do that, but then that your pay equity numbers are going to shift. This is part of that ongoing monitoring, which is important because not everyone gets hired on January 1 and fired on December 31st or terminated on December 31st. People, change positions throughout the year. Some will get pay raises at different points of the year, and new people come in, and some people leave, at any time of the year. So that kind of fluidity in your workforce needs to be captured, and having this tracking, a platform that's actually looking at your, that's sort of plugged into your payroll and your other data. And so it's sort of showing whether there's changes over time. And while you don't need to look at it every day, but you're going to want to periodically check to see where is it? How's our picture? We had a slew of hires, last month. What is it looking like now? Things like that. So keeping track of that. And as I said, if you are trying to get towards pay equity, you need to have a baseline to know where you are. And then when you set your goals, you can figure out whether you're actually close to achieving it. The phrase, what gets measured gets managed. That's kind of the idea. So, in this scenario, his one position, you can run that for all of your positions that you're thinking about posting come January 1. And so, but you're going to have to run the pay equity analysis beforehand in order to, figure out what your pay equity range should be in light of market data. Like right now, I've certainly heard of employers really just looking at the market, what are the ranges? And they're just looking at it that way. And they're not accounting for their own pay equity issues. So for example, let's say you have a significant difference in pay equity between men and women, and this is the software engineer manager, you have this range. Well, you would know, if you are hiring someone that's higher than that and they fall in the female category and you have a pay gap, you know that it will impact it one way, and if it's male, you'll impact it another way. So this is just really to give you insight of what your pay ranges should be, and also to keep track of how that's going to be impacted with hires. So this is an ability for you to have kind of a disciplined, formal procedure. And again, this is, you can do it flexibly. You can use this as guidance. You don't have to follow it to the letter, but know that if you fall outside of the sort of guided numbers, it will have an impact adversely, positively, et cetera. And this allows you to share fair and competitive offers in all your job listings. It prevents pay inequity from being created in the first place. If you stick to the numbers, and it really elevates your brand with external and internal pay benchmarking. Okay, next slide. So with that, let's launch the poll question. Do you need help developing a plan for meeting the requirements of SB 1162? Now, while this poll question is going on, let me take an opportunity now to answer questions. Okay. All right. Okay, hold on. I have to look at them. There's actually a lot. I may not be able to get to all of them. I have one question. How many employees does a company need to have to be required to submit this pay data report? And sort of a two-part question. Is it separate from California pay data report that's already due in May, every May? So the answer is 100 employees. That's how many employees you need to be subject to 1162. And also, if you have at least 100 labor contractors, you're going to be subject to a separate additional requirement. Now, I'm not sure, is it separate from the California pay data reports already due every May? I would need more specifics than that. Apologies. This is the pay data reporting, just generally speaking, what employers have to submit. It used to be in March. Now the deadline is May. So I have another question. Is this report different from the EEO2 report? The answer is yes. It's different in that the original EEO1, I think you were referring to EEO1 component 2 data reporting that was for that 2017-2018 year. It's certainly structured the same way, but there's some nuances to it. Number one, it's not just female, male, it's also non-binary. So it's an additional burden for employers to gather that data. So you're going to have to report it that way, number one. Number two, the way that the data is being reported is different. You have to submit mean and median pay data, in addition to just sort of what the pay data is. And so for background, the EEO1 component 2 report was basically, I think, 10-ish categories of positions. And you had to report the numbers in these different pay bands that were established by the Bureau of Labor Statistics. So they were like numbers, like I can't remember the numbers, but X dollars to Y dollars, and then Y dollars plus to another range. So they're different pay bounds, and then you're basically reporting how many in each. So the sort of basic format is the same, but now you're adding the nuances of the non-binary. You're also adding the nuance of the mean and median pay data. Okay. So I have another question here. Does the 100+ employees requirement apply to employers with 100 or more employees working in California, or just 100 or more employees nationally? So the answer is the latter. If you have at least 100 employees in the U.S. and you have at least one in California, then you're going to have to report. Now, mind you, you only have to report for those in California. That doesn't mean, like, just because the requirement is triggered doesn't mean you got to do it for everybody. It's just the ones that are assigned to California. Okay. I have another question here. Hold on. apologies, some of these are. There are a lot of questions regarding remote workers. So I'm going to try to answer them kind of generally speaking. So remote workers, that's one of the nuances of the California SB 973. That isn't any, 1162 didn't change that. But bottom line is, if you have remote workers and they are reporting to, they're assigned to California, that's going to be called a California employee. If they're in California, that's a California employee. Those are kind of the general rules. Okay. I have another question here. When you say minimum to maximum of a range, what if the typical hiring practice is to pay the minimum to midpoint and not the maximum of the actual range? Well, I believe the language, I have to look at the language specifically, but what it's asking for is a range that an employer reasonably expects to pay. So if the maximum is not part of that reasonable range, then you shouldn't be listing the maximum. Now, if it is part of that, like it's reasonably, the company reasonably expects to pay within that range, and just because it's more typical that it's in the midpoint, that doesn't change that, you don't want to, you're going to want to identify the range. And the fact that you typically pay in the midpoint doesn't change that. So I have another question here. Do we need to keep the job title and wage history for all positions, or just the history for the employee? So I think as far as I understand the question, and this is regarding the sort of record keeping requirements, and what you're going to want to do is you want to basically track it for all positions. So hopefully that answers the question. You want to track the job title and the wage history, and you want to track that for each position. And because it's the way it's framed, you're supposed to maintain records for the duration of each employee's employment and at least 3 years after termination. So what that tells me is you just need to keep track of all of your positions. Let's say you decide that you're going to not have a position anymore. If you're going to, like, for whatever reason, restructuring, what have you, the position no longer exists, and you have an employee that's just resigned or got terminated, whatever, you want to at least hold on for 3 years after that time. So big picture, you want to track job titles and wage history for all of your positions. When you get to a point where you no longer have that position, you want to figure out which employee last held that position, and then you can track it for 3 more years. I have another question here. It says, does it need to be a posted range, or can it just be a start rate? For example, can it be starting at $20 an hour? Does it need to show 20 to 22? The answer is the latter. Like, it's very unambiguous. It's pay scale. It's a salary range. So there's a minimum and a maximum. So, part of the reason why 1162, at least from what I hear, is causing a lot of consternation is it's different. It's different than what employers are used to. I've certainly seen historically a lot of position openings where it's $25 and up, or or starting salary is whatever, and that was common historically. But 1162 makes it clear you can't do that. You have to identify a range, and that is the trend. This is sort of where pay transparency is heading, if not already nationwide. And obviously it's like spotty in certain jurisdictions. And one of the things is sort of this public sentiment, like younger people, certainly younger relative to me, they are far more comfortable talking about pay. They expect pay ranges to be disclosed. They are more free sharing it with each other. That's just the trend of younger workers, particularly the professional workforce, where the competition is fierce. So this is all the more reason to push towards that. So because of this kind of sentiment, of pay range disclosures being a little bit more normal. Like, I've looked at certainly a number of studies that talked about employers' expectations, like, the importance of pay transparency. Like, I don't remember the statistic, maybe it was like at least 7% of workers, would rather work for a company that discloses their pay ranges. So what I'm saying is, here's the law that's really kind of pushing you to do it. And here's this tight labor market and all these workers wanting that, expecting that. Why not sort of embrace it instead of fighting it? Like, it's happening, you're required to do it. So why not get ahead of it, be proactive, figure out what your plan is in terms of how you're going to pay people, in a disciplined manner throughout your organization. And then so you can sort of post those things, post your salary ranges or what have you in a, that you're doing it fairly and you feel confident in it. Okay, let's see if we might have time for one or two more questions. Okay, there's a lot more of these questions kind of talking about those remote workers. I'm hoping that I've addressed it. If not, like, I'll go through each question. We'll have these answers posted, and we'll communicate with you in one form or fashion. But bottom line is, for remote workers, if you hit that 100 employee threshold nationwide and your employees are located, the ones you have to report for are the ones that are in California, assigned to California, California location. Okay, it says, here's another question. Oh, okay, I'm getting a lot of questions dealing with this pay scale. It says, can you talk a bit more about the interpretation of pay scale in SB 1162? My company has very broad pay bands, and we don't typically hire at the min-max with parameters based on market and internal equity. As an example, we may hire positions somewhere between 0.85 and 1.15. Is it permissible to post the range of 0.85 and 1.15, or would we be required to post the entire broader range? Well, you should be guided by pay scale. The way it was defined is basically the salary range for that position that the employer reasonably expects to pay. So it's broad. I'm not really sure what 0.85 and 1.15 mean, but basically, what is the minimum and maximum? I don't mean like a theoretical minimum and a theoretical maximum. I mean like the reasonable minimum salary that you're going to pay and the reasonable maximum that you're going to pay. So hopefully that answers that question. With that, we have run out of time. I thank you for participating. And as I said, we will get all the questions answered. So let me turn it back over to Mike Oganian, and thank you again.
Thank you, Joanna, for sharing your knowledge and time with us. This webinar will be available for playback for up to 90 days. Simply log into worldatwork.org and access your profile, but please allow 24 hours for that playback to appear. And a reminder that we are going to email a short survey at the end of the event. We highly appreciate your feedback. I'm going to stop the recording now and go ahead and share the HR, CI, and SHRM codes. Thank you, everyone, for attending. Have a wonderful day.